Public Protector Busisiwe Mkhwebane's fitness told office is again expected to be in question today as Parliament's Section 194 Impeachment Committee meets. It follows a Constitutional Court dismissal of Mkhwebane's rescission application last week. For more analysis on this, we're joined by legal analyst Mpumelelo Zikalala. Mr. Zikalala, always good to have you on Newzroom Afrika. So, as things stand, is there a path clear for Parliament to continue with this impeachment process without any further legal wrangling, do you think?
Currently, on a technical basis, I would say yes. Let's remember there's no any constitutional court which is waited on or any decision by the Concourt. There is, however, this application is taking place at the Western Cape High Court, which will need to be decided in due course. Also, let's remember that there's a letter which was written by the legal representatives of the Public Protector, in which they are saying to the Concourt, give us an audience so that we can be heard and be able to deal with this matter adequately. We are of the view that what you have done, you've transgressed the Constitution. In fact, you haven't given us an opportunity to ventilate our matter, regardless of the fact that it is a decision. But I think, and I have a strong suspicion that they are going to use the same Rule 42, which applies the same in the Superior Court Act as in the Concourt, in terms of saying, you have made an error by not affording us an opportunity to present paper submissions. What you are doing is against the law. In fact, it's an utmost form of injustice. Give us an opportunity to respond so that you are able to do so. The backing of that being within the Constitution, Section 34 says that matters must be decided publicly. I think they want to work on the description or the interpretation of the decided publicly statement in terms of saying, yes, it can be done on paper, but in these circumstances, they are dealing with a matter which is highly technical, very important, has never been done before in terms of removing a public protector, and you can't just wish it away on paper. Give us an opportunity to make paper submissions so that everything can be okay.
How much has the public protector's legal argument in the various rescission matters changed, evolved, and what does that mean then for any future prospects of success?
I think on this one, it may be just on a technical basis of saying that hear us so that you're able to, maybe you can be able to convince you. Of course, you can't predict what the legal reps are going to say once the matter is at court, but at the end of the day, I don't think it's going to change that much. Let's remember, the Constitution does allow for a public protector to be removed. The Constitution does allow for a president to suspend a public protector if it needs be. So in terms of fighting the technicality of the suspension, I think it's not going to work. However, you can deal with the rules that have been stated or that have been adopted. In this case, the courts in the previous occasions have said, public protector, we do realize that there are rules which are supposed to apply to your removal. The only one which we are going to concede, which was wrong, is that you are not supposed to be given a legal rep to represent you. We are going to overturn that one, but everything else will remain the same. So for me, I think the fight can be, yes, technically warranted at this particular stage, but I think once the proceedings have started, you can start to attack, maybe, for example, the presiding officers, attack who makes up the particular committee. Are they going to be objective? Are they going to be biased? Do they come from certain political parties that have an interest in any matters that the public protector is dealing with? Is the man and the conduct of orchestrating those proceedings in question? But most importantly, what are the transgressions in which the public protector is facing? Let's remember, there are only 3 instances in which a public protector can be removed. One is misconduct, incapacity, and incompetence. If it doesn't fit into those 3, then the public protector will come back and say, in fact, you have brought me here on the basis of a witch hunt. There's no tangible evidence that is there. You can't check the fact that there are some cases that have been reviewed in court that have dealt with before. That's why we have this particular system, so that at the end of the day, we're able to correct each other.
So we spoke about the Constitutional Court process, but it's not the only issue involving the public protector. As you were referencing, there is a matter in the Western Cape to do with an alleged leaking of which way the Constitutional Court was going to swing on her rescission application, right? Does the fact that there's more than one process present any unique challenges in law, especially if Parliament is indeed, I know you touched on it earlier, but is indeed planning to push ahead with its bit?
It shouldn't, but I do suspect that the public protector is going to raise this particular point in limine and say, you can't start with these proceedings when you haven't dealt with my queries, because I want you to make sure that everything that has been done here is above board and is in line with the rules of natural justice. So if I come to you as a complaining party and not listening to my complaints, then it definitely means that when I make submissions that there's a hidden agenda. You shouldn't wish them away. You should look into them and make sure that whatever decision in which you are going to take is one which can stand the test of time and being reviewed in court. It also makes a very interesting argument because let's remember who the committee members are. It's our very own parliamentarians. Now, it's going to be very difficult to prove the element of independence, the element of saying that they are not biased from any political party that they are coming from when they are part and parcel of the decisions which are taken in Parliament. So if an investigation has been done against a member of the ANC, for example, that's the very first point in which the public protector will say, you are not qualified to sit there because you have an interest in the matters that I've handled before. So I don't think you're going to be objective in coming to the conclusion that you have transgressed or have committed these allegations which I'm accused of which what must be reminded is that the parliamentary committee is limited only to 3 transgressions: misconduct, incapacity, incompetence. Anything about that doesn't relate to that, it can't be imputed upon the public protector, hence she can't be removed.
So if not Parliament dealing with the impeachment of the public protector on the grounds of perhaps a perceived or real bias, and the courts too have in recent days been accused of an apparent bias against her, especially after that alleged Ismail leak of which way the Constitutional Court was going to rule, who then will deal with this without being accused of having taken a partisan approach or any other bias against her?
I think the current structures are the appropriate structures to deal with this matter, but it must be done publicly. So if you want to say to the public protector, your case does not have merit, even if you know when you are reading those particular papers that there's absolutely no way in which you can decide in their favor, allow or give them an opportunity or give her an opportunity to go to court with a legal team to present a case. If it's not on any other rules in which you can come up with, look at the Constitution. It's very clear. Section 34 tells that access to our court simply means that matters must be decided publicly, which is why when matters sit, even members of the media are invited or are able to cover live coverages of those proceedings, because justice must not only be heard or be read, it must also be seen to be done. So if you are going to be given a perfect opportunity, it is clear from the mind of the public protector and the thousands of South Africans that indeed they were able to make submissions. There were certain questions which were put to either of the teams. They were able to deal with them comprehensively. Then it's easy to see that in this particular case, you don't have a case public protector. In this case, you do have a case. So that is what the public protector is saying in terms of saying, please allow me an opportunity to make submissions before you even start this particular process. But if they give into that or that particular application succeeds, it may mean that these proceedings which are going to or ought to have taken place in Parliament will be stalled again once the Constitutional Court is dealing with let's call it the rescission application, resubmitted or times 2.
I don't know if you're a betting man, but I wonder what you think are the chances that that process in Parliament will actually ever get off the ground at this stage.
I think it will. I think there'll come a time in which Parliament will say, we haven't done this before, we are going to do it for the first time. Let's rather let's do our mistakes now so that when it comes back at a later stage, we're going to be clear. So they will say, the parliamentary process, let it begin, at least let the internal or the preparatory purposes of it start, so that when we get a green light in terms of saying we can move on with this, we're more than covered. Let's also remember where they derive their powers from, the Constitution and from the courts. So you don't need a court order to hold a particular parliamentary process. All that you need is for the Section 194 to be satisfied with. In this case, they would say we have done that. The only thing that can be done at a later stage is that once those proceedings have completed, the public protector definitely will take the matter on review and say to our courts, look at the amount of irregularities that have taken place, look at the elements of biasness that have taken place. Surely this particular process was not a fair one. And in fact, my rights were infringed when this particular committee sat and decided my fate.
Sounds like one of those that you and I will be discussing in 10 years still. But thank you very much, Mpumelelo Zikalala, for speaking to us today.